Hello everybody, it's Gerry Oginski. Today's video topic is, you sued your doctor for medical malpractice, and now your doctor wants to turn around and countersue you for filing a frivolous lawsuit. Can he do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now let's envision this scenario. You believe that your doctor caused you significant harm and injury. You believe he was careless at a particular time, at a particular day. And now, as a result of that improper medical care, he caused you significant harm and injury. You decide you're going to bring a lawsuit against him. For what? For medical malpractice. But you need to know that before you can go ahead and do that, you need a medical expert, typically a board-certified medical expert, to go ahead and confirm, number one, that there was wrongdoing, number two, that the wrongdoing caused injury, and number three, that your injury is significant or permanent. And all three of those things must be confirmed by a doctor who's either treated you or reviewed all of your records. Wow, this looks really weird when I come close. How do you like that? So, keep going. We're telling your friends to join your video. Okay, that's great. So, now, you bring a lawsuit. The first thing that the doctor and his attorneys say once the papers are served is, hey, why are you suing me? I didn't do anything wrong. Why are you suing me? I didn't violate the standard of care. Okay, we're still spreading the word that you're live. This may take a minute. Okay, that's great. So the doctor and his attorney turn around and say, these allegations are bull. They're total garbage. Why are you bothering to sue me? Okay, that's number one. He says, I did nothing wrong. Number two, he said, he says, wait a second. If I did something wrong, then guess what, patient? So did you. So now he pushes the blame off. He throws it from him onto you, the patient. Then he turns around and says, hey, wait a second. You know, if I did something wrong and you, the patient, did something wrong, well, guess what? Whatever I did or didn't do didn't cause your injuries. Imagine that. And then he turns around and says, you know what? Even if I did something wrong and I caused your injuries really are not as bad as you claim them to be. Now, let's see if I can include someone here. I'm going to invite a friend. Let's see if I can get a couple people on here. And let's see who else I can get on here. Okay. Let's see a whole bunch of people. And let's see if they're available right now, because I think this will be great to get them on here. Here we go. Get a couple others right here. A few others. There we go. And now I want to continue in 1 second. Samson, there you go. I'll invite you too. Excellent. Okay. So now, the doctor is furious. He's so upset. He's angry. And now he turns around to his lawyer and says, hey, wait a second. Is there any way that I can sue the patient for filing a frivolous lawsuit? Can I do that? You know what the answer is? Maybe yes, and maybe no. So let me tell you what I mean by this. Anytime a doctor wants to bring a countersuit, first he's got to do a couple of things. First, he has to defend your lawsuit. That's number one. So there are a number of defenses that he's going to throw up to try and throw obstacles in your path. And then, if he wants to bring his own lawsuit against you, the patient, for bringing your lawsuit against him, now the tables are turned. Now he has an obligation to do what you are doing, which means he now has to support his claim that your lawsuit, that your claims are in fact frivolous. Now, how does he do that? Well, you know, in our case, where we bring a lawsuit on behalf of an injured patient, we have to show that we are more likely right than wrong, that what you are claiming is true. And in medical malpractice cases here in New York, what we have to do is we have to get a medical expert to support our claims. But we are the ones who have to show that we are slightly more likely right than wrong. You know, in law, we call that the burden of proof. So the reality is that we don't actually have to prove much of anything, because as the person bringing the lawsuit, in a civil lawsuit here in New York, we don't have to show with 100% certainty that what you're claiming is true. We don't even have to show 75% or 60%. We only have to show 50.0001%. We only have to tip the scales ever so slightly in your favor in order to justify a verdict in your favor. That is so critical. So now let's turn this around. So now you brought a lawsuit against your doctor. The doctor says, hey, wait a second, I did nothing wrong. And now it's time for a water break. Okay. So now the doctor's upset. He's furious. He tells his attorney, listen, I want to countersue the patient for filing a frivolous lawsuit. In order to do that, he has to show that he is more likely right than wrong, that number one, the lawsuit was frivolous. Now, how do you do that? How do you determine that a lawsuit is frivolous? I guarantee you that if you ask any doctor in New York whether or not lawsuits against them are frivolous, they will 100% of the time say, of course, all lawsuits against each doctor are frivolous, right? You'd think that would be true. The fact is that they're not frivolous. They think they're frivolous, but now they have an obligation to prove it. Well, how do you prove that something is frivolous? I'll tell you how the doctor perceives it. So what happens is when you bring a lawsuit and now you go through the entire litigation process and now get to trial 2 or 3 years down the road. Now, if a jury of 6 people in the community determine that you are not more likely right than wrong as the patient who's bringing the lawsuit, then the doctor wins the case. At that point, the doctor will turn around and say, see, I was vindicated. I did nothing wrong. The jury told me I did nothing wrong. Therefore, patient, your claim was frivolous. Well, no, that's not exactly how it works. You see, it wasn't frivolous. It wasn't frivolous from the patient's standpoint. It wasn't frivolous from the medical expert standpoint, the expert who they retained, who the patient retained, to go ahead and support the claim. There's no frivolity there. So how is a doctor going to prove that his colleague, somebody who's a specialist in the same specialty, typically the same field of medicine as he is, that this was a frivolous case? That's extremely difficult to show. So now the doctor has to bring in his own experts to argue that, hey, this case never should have been brought. It was obvious to everybody involved that this was frivolous. And then he has to show to the jury that he is more likely right than wrong, that this claim was in fact frivolous. And the definition of frivolous may not be what you and I perceive it to be, but what the law perceives it to be, what the law recognizes a frivolous case to be. So, when you look at it from the viewpoint of the patient bringing the lawsuit, we are required by law to have that medical expert confirm that we have a valid case. That's the requirement to prevent frivolous lawsuits from occurring. The mere fact that a jury has now determined that you are not entitled to a verdict in your favor does not mean that your case is frivolous. It simply means that the jury did not believe that you were entitled to a verdict in your favor. Maybe they felt the doctor did not do anything wrong, or maybe they felt he did something wrong, but his wrongdoing did not cause or contribute to your injuries. Or maybe they felt that your injuries were not significant, even though the doctor may have done something wrong, and even though his wrongdoing may have caused or contributed to your problems. So that's a very interesting point. So when I raised the question at the very beginning of this video, which is, after you bring a lawsuit against your doctor, and now the doctor turns around and says, hey, this is bullshit, this is garbage, I want to sue the patient for bringing a frivolous lawsuit. The mere fact that someone has a legal right to bring a lawsuit does not mean it's frivolous until a jury reaches a decision, until they come to the conclusion that they are or are not more likely right than wrong. And if, in fact, the jury decides in favor of the doctor, again, that does not necessarily mean that the case is frivolous. Thanks so much for the thumbs up. That's the point here. So I understand the doctor's, what's a good way to phrase it? The doctor's angriness? No, that's not really a word. The doctor's frustration with having to go through the lawsuit process. I understand the patient's frustration with now suffering these injuries as a result of her belief that the doctor was careless and caused her all this harm. So I understand that too. But when you bring a countersuit, you are now the one who's bringing the lawsuit, and now you have the obligation to show to a jury that you are more likely right than wrong and entitled to a verdict on those claims in your favor. So why do I share this great information with you? I share it with you just to give you an inside look at what happens in these lawsuits, these civil lawsuits here in New York, involving accident cases, medical malpractice cases, and even wrongful death cases here in New York. You know, I recognize you're watching this video because it comes up in your Facebook feed, and now you get interested and you started to watch it. Well, if that's you, terrific. But more likely, you're searching for information, and now this video came up in your search, and you have more questions that need answers. Well, here's what I want you to do. If, in fact, your matter happened here in New York, and you do have questions that need answers, what I invite you to do is pick up the phone and give me a call. You know, I answer questions just like yours every single day, and I'd love to chat with you. Importantly, if you have not started a case yet, I don't get involved in cases that have already been started by someone else. So if that fits you, if you are the person that I'm talking to right now, then I invite you to pick up the phone and call me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day. Goodbye, everybody.